talk to each of them individually about the locations of the parking enforcement officers.
Haven't they called you and asked where they are? Have you
No.
seen any?
No.
And you've not called any of the other folks, other defendants, and told them where the parking enforcement officers are?
No, maybe I misspoke or you misheard me. I said I have not called them all in totality about the locations of
Oh.
these individuals.
I'm sorry, I didn't parse that out as you did. You haven't called all 5 of them at the same time. Is that what you're saying?
Yeah, I haven't called each of them individually either.
But
I haven't, if you're trying to get at my use of the radio, the incident that Alan had brought up about me sitting outside the post office, for example, I was out on a walk and decided to sit on a bench and get some sun as I read a book, and then I heard someone yell and I tried to figure out what was going on, and I see someone waving, here I am out the window, and I see Alan drive around the circle, so I say, hey, Alan's on South Main by the post office. You know, that's the extent of that. I don't go out and looking for the parking enforcement employees to learn to ascertain the locations and to transmit that on. No.
But you have on occasion, haven't you? On occasion.
I have admitted to that, have I not?
I really can't understand whether you've admitted to it or not.
Well, you should listen, sir.
Okay, well, there's a lot of discussion going on. I'm
Okay,
trying to listen.
let's keep it to question and answers.
So my next question is this. Do you have any of these cards that Exhibit 4?
I don't believe so.
Have you ever had any in your pocket or in your possession?
Potentially.
Potentially. And have you potentially placed them on vehicles?
No. I never have.
Have you handed them out?
No.
Is there anything with regard to activities against the parking enforcement officers on your website?
No. Again, which website? It's not my website, sir. It's Complex Decentralized.
Yeah, I said on the website.
There's a Robin Hood page at King Coplock.
Well, let me ask you this. Would you say that you really haven't been participating too much? You would agree then, wouldn't you, to stay 30 feet back from each of these people and not engage in anything touching or taunting or obstructing or detaining or hindering or impeding or blocking them or intimidating them in any way while they do their jobs? If you have not engaged in those activities, as you say, then you wouldn't have any objection to staying 30 feet back, would you?
Objection, relevance.
Okay, I'm going to piece out your question. I would not, and I have not, and I don't foresee myself in the future engaging in an action that detains somebody. Because to me, if it's an initiatory force, I would not do that to anybody. If I see somebody, for example, out on the street beating up some people, I might try to detain them and say, diffuse the situation, yes. So I'm not going to come to some absolute statement with you, but as to the first part of your question, is it an issue for me to stay 30 feet from these individuals? I would most definitely not be willing to accept that, because that would, why would I want to, I'm not harming anybody by being in the proximity. I'm not victimizing anybody. I will definitely not set that precedent and be complacent with the claimed right usurpations that Thomas Mullins and the rest of y'all are trying to do.
So you would agree then not to be within 30 feet of the 3 PEOs
No.
and taunt them?
Sir, I don't.
Listen to my question. Let's just take it one step at a time. You would agree not to taunt them within 30 feet, wouldn't you?
No, it's my free speech right if I want to. It depends what your definition of taunt is as well. But again, my purpose is not to cause anybody. I don't go out with a goal in mind to cause someone frustration or stress. But if I see someone wronging another, then yes, I will call them out. And if that call makes a certain police employee frustrated or they consider that subjectively to be a taunt, then so be it. But I'm going to speak my mind, because I feel like if you don't, then if that's allowed to get away from it, it becomes difficult to do so in the future when those rights claims are made even more so.
Thank you.
your position factually on some of the allegations, because you've said a couple times in hearings that you feel that, you know, obviously you take issue with, because you said this several times, with the action overall, but you feel in particular to involve you is not correct, because you've had no involvement in the activities that are complained of. If you could just elaborate as to why you feel that you in particular should not have been named in this action.
I mean, I think it's pretty clear, there was 3 individuals, park enforcement officers, who stated, you know, 5 to 6 people, and only one, you know, one of the 3, Alan, who just testified, noted myself, and the overview of the interactions we've had, the number and the type have, you know, definitely not equated to me being in the wrong for anything. You know, none of these folks have done anything. But I most certainly, I mean, none of these folks, to my knowledge, obviously I haven't been around all of them while they're out doing whatever. I can't speak to everything they do, but to my knowledge, no one's, you know, caused anything that I would say is a criminal action. Therefore, there's no claim anybody can make to say you have to make me whole because you harmed me. And that's most certainly myself. I haven't, you know, I'm online, I'm doing other things, and then I get all this paperwork saying I have to show up, and for what? You know, it's guilt by, I mean, it's ridiculous.
And the reason I'm going there is because one of the very first things she said when you took the stand this afternoon was that you chose not to be involved in the activities of the Robin Hooders. And I just wanted to make sure that I understood. Was that in fact your testimony?
I mean, I support them, I just prefer to allocate my time to other activities.
So to the extent they've been involved in, for lack of a better term, Robin Hooding, you haven't, other than the occasion that you talked about and perhaps some contact with some of the others regarding location, you deny any involvement in Robin Hooding activity?
Yeah, I mean, I think that's a factual statement. There's been no other testimony or objective evidence pointed to demonstrate otherwise.
And I was asking you whether you specifically deny any direct involvement in their activities.
Sure. I mean, the extent of my involvement has been, I'm happy to state, and I have stated, and it's come to, you know, come out here today. So that's the extent of my involvement.
Any further questions from either council? Anything further that you want to say of a factual matter, Mr. Iyer?
I mean, I just encourage the people who work for the city that are involved in this to think about, I mean, just, this, obviously the motions are set in gear, but just in the future, I hope you would speak out when you see a lot of ridiculous things happening, you know, about allocation of funds and mischaracterizations of people and things like that. I mean, we're all humans, and we want to look out for each other. We don't want to create these divisions perpetuated by, you know, claims of authority and things.
You step down. I think it's now 4:15. I think practically, even if we were to try to resume, Mr. Gibbons pretty clear that we wouldn't even complete his direct examination, further direct examination. What I'm really looking for now is a sense from council how much additional time is this another full day?
Well, you know, I can't speak to the case presented by the city.
Yes.
But I'm anticipating the defense case, for at least planning purposes, that we are going to have all 5 defendants who are going to testify. Now, first of all, their testimony, direct testimony, I expect to be considerably more extensive than the last witness, because of the certainly much greater involvement in the Robin program. But more importantly, if we continue with this discourse about philosophy, the detail that it's been, I mean, you can easily imagine some of these witnesses taking a couple of hours each. So, I mean, that's, again, it goes back to my concern about trying to limit the scope of what's really at issue here. Just partly just to least half of that, with judging by this afternoon, would be cross-examination.
Your Honor, sorry that it's taking so long.
You know, let me add though, because, and I recognize there are strong feelings on both sides of this question. I don't mean to constrain the presentations here. I want to give both sides a fair opportunity to present. If it winds up taking another 2 or 3 days, then so be it. That's just how long sometimes these things take. I think as a practical matter, for example, one of the issues was the identification of individual defendants' description of their roles. I thought that was a fair objection, and that has resulted in the presentations taking longer. But that's okay. I would rather have the facts and have everything laid out and give all parties an opportunity to present. So I think what I'm hearing is that this is probably another 2 to 3 days to complete. Maybe optimistically 2 days, maybe you have another half day, Attorney Bauer, I don't know, but a day and a half, it's at least another 2 days. So to plan for anything less would not be realistic. Is that fair?
I think it's fair to say, I have Alan I'm going to put on, finish his testimony. I have Jane, who is one of the plaintiffs. And then I do have some supporting witnesses as well. We got through one of them, counselor. I mean, Judge, with regard to the Scott case, which has been cited to you in the briefing, it was a 9-day bench trial. So my point is that
You're actually quicker and more efficient than I am.
fishing for compliments.
Well, no, if I could follow up that, if it's true that if you look at many of the abortion cases, the Scott case is one of the abortion cases, they do talk about trials of 2 weeks, 3 weeks, or whatever. But if you look at the opinions, the appellate court opinions, and they take this, 3-week trial, put it down, it has like 1-page significance. So I guess my point again is that although there is, I agree, potential here for and we haven't even talked about the hundreds of hours of video tapes that are available. I'm just saying that I still continue to believe that if we got the legal issues clarified and narrowed, and maybe there's been some progress on that today. And as I said, I do intend to file a motion to dismiss. I do think that that's going to enable us to proceed with more speed than this result.
Well, I would like, it's obvious we're not going to conclude today, but I would like to frankly request my brother that we can have some type of good faith agreement that some of the evidence that came in today, that not continue during this hiatus until we come back in here. Not with prejudice, it's an understanding, it's not a court order, but that we have some peace and tranquility out on the job
But if I can
between now and then.
make our position clear, that is that nothing has occurred to date on behalf of any of my clients that is improper, that there has been no verified testimony today of any legally improper activity, and then accordingly, I would not recommend to them anything in terms of any type of modification of their activities, which I feel is being something that is well within their First Amendment rights to determine.
I'm not, and I think I said this to counsel before we get started, but I'm not gonna issue any kind of temporary or preliminary order right now. I think there are very significant legal and constitutional issues that I've yet to resolve regarding the claims in this case, so I'm not prepared to issue any even temporary injunctive relief right now. I will say though that obviously, if it's some period of time and some event should take place between now and then, and it bears on some of the issues, I wouldn't be surprised if the city tries to introduce any of that evidence as we go forward. But I'm not gonna. I think these are, as I've said, I've yet to find a single analogous case from another jurisdiction where involving tortious interference with contractual relations claim in a context like this. And secondly, I do think there are very serious constitutional issues that are raised by this case, and I want to take my time to make sure I get it right, rather than rush to any kind of decision before I'm prepared to do that. So, I apologize, these things take some time, but that's just the reality of how long it's gonna take. And we'll get you in as soon as we possibly can, and I made a proposal for this Friday, but it's clear from talking to council that date is not going to work. But I'll talk to the clerk, and as soon as we can get a couple of days that we'll work with council, we'll get this thing in and proceed.
And I think we'd be happy to get on the phone with the clerk.
Yeah,
Coordinate.
I would expect that Clerk Peel will be in touch with both council on the case. Mr. Iyer, you'd be involved, but I understand you're going to be away from what you represented at the bench for the next 4 to 6 months. Is that correct?
That's good.
Thank you. And you have counsel, so if you want to say something to your counsel, so Zager has